Welcome to 6-7. This is your daily political update. This is me, Sanjay Bhargav. Let's get started. Today we will talk about Darjeeling, a beautiful hill town, and why people there are asking for a new state called Gorkhaland. The Gorkhaland issue is about the demand for a separate state carved out of northern Bengal. West Bengal, Darjeeling, Kalimpong, Doar, Terai, based on the distinct identity of Nepali-speaking Gorkhas. Constitutionally, the creation of new state like Gorkhaland can only happen through Articles 2 and 3 of the Indian Constitution, which empower Parliament to form new states, alter the boundaries, or rename regions. And what is Gorkhaland issue? The location is Darjeeling, Kalimpong, Kurseong, Doar, and Terai in North Bengal. And the people, mostly Nepali speaking Gorkhas, who feel culturally different from the Bengali speaking majority in West Bengal. And the demand is a separate state called Gorkhaland to protect their language, culture, and identity. And the history of this issue is the demand started as early as 1907 with petitions to the British government. It became strong in the 1980s under the Subhash Ghai Gorkha National Liberation Front and later under Bimal Gurun's Gorkha Janmukti Morcha. Let's understand the constitutional and legal basis governing this issue. Article 2 and 3 of the Indian Constitution says, Article 2 of the Constitution says it allows the Parliament to admit new states into the Union, while Article 3 allows Parliament to create new states by separating territory from an existing state or by merging or dividing states. And the process is, first of all, a bill is introduced in Parliament. The President refers it to the concerned state legislature. In the case of Gorkhaland, it is West Bengal Assembly for its opinion. Parliament can pass the bill even if the state assembly disagrees. For example, in Telangana in 2014, Jharkhand in 2000, Chhattisgarh in 2000 were created using Article 3 of the Indian Constitution. And the current situation in Gorkhaland is leaders like BJP promise a constitutional solution but avoid committing to be dividing Bengal. Trinamool Congress opposes separation, saying Bengal must remain united. And the political context of the Darjeeling seat, which is in polls, go to polls on April 24, 2026. BJP often gains support in Darjeeling by promising recognition of Gorkha identity but avoids promising a separate state. The Trinamool Congress strongly opposes division of Bengal, instead offering developmental and autonomy through bodies like the Gorkhaland Territorial Administration. The local Gorkha parties such as GNLF, GJM push for permanent political solutions, sometimes aligning with nation parties for leverage. So, the Gorkhaland issue is about people in Darjeeling wanting their own state to protect their identity. The constitution gives a way to create new states, but it needs parliament approval. Until then, the debate between BJP, Trinamool Congress, and Gorkha leaders continues. Let's keep watching how this story unfolds. And the next story is, today we will learn about Umar Khalid, a student leader, and why the Supreme Court said he cannot get bail right now. The Supreme Court of India has rejected activist Umar Khalid's plea to review its earlier order denying him bail in 2020 Delhi riots conspiracy case, saying there were no good grounds to reopen the matter. He remains in custody under the Unlawful Activities Prevention Act, which imposes strict limits on bail. Let's understand the Umar Khalid's story. He is a former student of and a leader from the Jawaharlal Nehru University, and he was arrested in September 2020 after the Delhi riots. Delhi police accused him of being part of a larger conspiracy behind the Delhi riots of February 2020, which took place during the protest against the Citizenship Amendment Act. Charges are, he faces allegations under the Indian Penal Code for conspiracy and under the Unlawful Activities Prevention Act, a special anti-terror law. Accusations are, police say he gave provocative speeches and helped plan protests that turned violent, leading to 53 deaths and over 700 injuries. Let's understand why the Supreme Court rejected his review. earlier decision on January 5, 2026, the court had already denied him bail, saying there were reasonable grounds to believe the allegations. And the review petition was filed on April 20, 2026. Khalid asked the court to reconsider. Court's response is it found no error in its earlier judgment. It said prosecution material shows his role in planning and mobilization. It rejected his request for an open court hearing. Review petitions are usually decided in chambers. The result is bail remains denied. He can only file a fresh bail plea after 1 year or after key witnesses are examined. Let's understand the constitutional and legal basis governed. Article 21 guarantees personal liberty, but it is not absolute. Parliament can restrict it through special laws. Article 137 allows the Supreme Court to review its own judgments, but only if there is a clear error or injustice. Unlawful Activities Prevention Act, Section 43D, Clause 5 makes bail very difficult. Courts cannot grant bail if there are reasonable grounds to believe the accusations are true. And the court's view is that delay in trial is not enough to automatically grant bail in national security cases. So the story shows us that in India freedom is important, but the law can put limits when national security is involved. The Supreme Court said Umar Khalid's case must wait because the rules under Unlawful Activities and Prevention Act are very strict. The Supreme Court has rejected Umar Khalid's review petition against denial of bail in the 2020 Delhi riots conspiracy case, citing prima facie evidence under the Unlawful Activities Prevention Act. Today we will discuss the Priyadarshini Mattoo case and ask, can a life convict ever walk out of a jail in India? Yes, a convict can walk out of jail in India, but only through the legal process of premature release or remission. In the Priyadarshini Mattoo case, Santosh Kumar Singh, the convict, has spent over 30 years in custody and is seeking release, but the Sentence Review Board has repeatedly rejected his plea, citing the heinous nature of the crime. The Delhi High Court has questioned whether such decisions are being made on public sentiment rather than legal principles. Let's understand the case background. Victim is Priyadarshini Mattoo, a 25-year-old law student. And the crime is she was raped and murdered in 1996 by her senior Santosh Kumar Singh. And the trial history of Santosh Kumar Singh is he was acquitted by trial court in 1999. He was convicted and given death penalty by Delhi High Court in 2006. Supreme Court in 2010 commuted death sentence to life imprisonment. And the custody. Singh has now spent over 30 years in jail. Let's understand the constitutional and legal basis governing this issue. Article 72, which says about President's power. President can grant pardon, remission, or commutation of sentences. Article 161, it says about Governor's power. Governor of a state has similar powers. Bharatiya Nagarik Suraksha Sanhita, which says Section 473 and 474 allow state governments to grant remission. Section 475 says for crimes where death penalty was possible, convict must serve a minimum 14 years before release can be considered. And the Sentence Review Board says it reviews cases of life convicts. Considers factors like conduct in jail, reformation, risk to society, and public peace. In Santosh Kumar Singh's case, Sentence Review Board rejected release citing heinous crime and wrong example for society. Let's understand the why debate is started. Delhi High Court's view is that it criticized the Sentence Review Board for being influenced by public perception. It said decision must be based on objective criteria like reformation and rehabilitation. It pointed out that other convicts in similar cases like the Tandoor murder case were released after 23 years. And the family's view is that victim's family strongly opposes release, saying the crime was too grave. And the legal question is, should punishment be eternal or should reformation after decades in custody allow a chance at freedom? So, in the Priyadarshini Mattoo case, the law says a life convict can walk out of a jail if reformed, but society's demand for justice makes it very difficult. The Constitution gives powers of mercy, but courts must decide whether punishment ends or continues forever. Today, we look at Andhra Pradesh, where district collectors are now competing like entrepreneurs to bring investments into their regions. In Andhra Pradesh, Chief Minister N. Chandrababu Naidu has asked district collector to actively compete for investments, even ranking districts based on how much capital and jobs they attract. This unusual move raises debate. Will bureaucrats become more powerful than elected politicians, or is this simply a way to speed up development? Let's understand what is the news. Collector Conference 2026. Chief Minister N. Chandrababu Naidu directed collectors to hold meetings with investors, clear proposals quickly, and promote industries in their districts. And the ranking system. Districts will be ranked on speed of doing business and investment or job creation. Focus areas are Vishakhapatnam, Amaravati, and Tirupati are being developed as major economic hubs. And the goal is faster approvals, better infrastructure, and more employment opportunities for local youth. Let's understand the constitutional and legal basis governing this issue. Role of collectors. Collectors are senior IAS officers appointed by the state government. They act as administrative head of a district implementing government policies. Political executive, that is, the persons who are elected by the people. Under the constitution, elected representatives such as chief minister, ministers, MLAs hold ultimate decision-making power. Bureaucrats cannot override political authority, they only execute policies. Checks and balances. Collectors' competition is within the framework of state's policy. Any major industrial policy or land allocation still requires cabinet approval. Let's understand the perspectives on this issue. Positive view on this issue they are efficiency. Collectors know local strengths such as land, resources, manpower, and can match investors quickly. Accountability. Rankings create pressure for better performance. Development. Faster clearances mean industries can start production sooner, boosting jobs and income. The critical view is that bureaucratic overreach. If collectors become the main drivers of investment, ministers may lose influence. Unequal playing field. Districts with natural advantages such as ports, airports, proximity to cities will always rank higher, leaving others behind. Democratic concerns. Elected leaders should set priorities. Bureaucrats are not directly answerable to the people. And the balanced view is that collectors as facilitators, politicians as decision makers. Healthy competition can improve governance, but political oversight must remain strong. So, Andhra Pradesh experiment shows us a new way of governance, bureaucrats competing for investments. Whether this strengthens development or weakens democracy will depend on how well The balance between politicians and administrators is maintained. West Bengal election drama has taken a sharp turn. Humayun Kabir, AIMIM, and a viral video have set the stage for a fierce battle over Muslim votes. The controversy in West Bengal revolves around Humayun Kabir, a suspended Trinamool Congress MLA who briefly allied with Asaduddin Owaisi's AIMIM. A viral video allegedly showed Kabir discussing a 1,000 crore deal with the BJP to split Muslim votes and even referencing Babri Masjid. This led AIMIM to break ties, sparking a political storm with BJP, Trinamool Congress, and Congress, all accusing each other of manipulating minority voters. Let's understand what happened. Alliance was formed. AIMIM and Kabir's Aam Janata Unnayan Party (AJUP) announced a pre-poll alliance in March 2026. In the viral video, a 20-minute clip surfaced online showing Kabir allegedly talking about a 1,000 crore deal with the BJP to mislead Muslims and references to Babri Masjid. On April 10, AIMIM chief Asaduddin Owaisi announced withdrawal from the alliance, saying AIMIM cannot associate with statements questioning Muslim integrity. And the Kabir's response is he denied the allegations, calling the video fake and politically motivated. Let's understand the role of major parties in this issue. Trinamool Congress. It released the video, accused Kabir of colluding with the BJP to split Muslim votes. It demanded an ED probe into the alleged deal. BJP. It denied the involvement. Amit Shah said BJP would rather sit in opposition for 20 years than align with those talking of Babri Masjid. And the Congress criticized both AIMIM and Kabir, claiming their moves only helped BJP by dividing minority votes. AIMIM. It distanced itself, saying it will contest independently to give Muslims an independent political voice. Let's understand the perspectives on this issue. Supporters' view is that Kabir is gaining traction among Muslims by raising issues of neglect and promising strong representation. AIMIM's exit shows it wants to protect credibility and avoid being seen as a pawn in BJP strategies. Critics' view is that the controversy is seen as a deliberate attempt to split Muslim votes, such as 27% of the Bengal's electorate. Trinamool Congress argues that smaller parties like AIMIM and AJUP indirectly help BJP by weakening the minority vote bank. And the balanced view is that viral video may be politically timed, but it highlights the fragile trust of Muslim voters. This episode shows how alliances can collapse quickly in Bengal's volatile political environment. In the end, the Humayun Kabir and AIMIM breakup is not just about one alliance, but about the bigger battle for Bengal's Muslim votes, a fight where Trinamool Congress, BJP, and Congress all see high stakes. In Madhya Pradesh, a shocking video shows BJP MLA Pritam Singh Lodhi threatening to fill a police officer's bungalow with a cow dung, all because of action taken against his son. The controversy in Madhya Pradesh erupted after BJP MLA Pritam Singh Lodhi threatened to fill a police officer's bungalow with a cow dung. His anger stemmed from police action against his son, Dinesh Lodhi, who allegedly rammed his SUV into 5 people in Karera. The viral video of Lodhi's remarks sparked condemnation from the IPS Association, opposition Congress, and even his own party, forcing him to apologize. Let's understand what happened. On April 16, 2026, Dinesh Lodhi, son of MLA Pritam Singh Lodhi, allegedly drove his Thar SUV into 5 people near Karera police station. And the police action was his driving license was cancelled and he was warned not to appear in Karera again. MLA's reaction was Lodhi lashed out at SDOP Ayush Jakar, questioning his authority and threatening to mobilize 10,000 supporters to dump cow dung at the officer's residence. In the viral video is his remarks, "Does Carrera belong to your father? And my hand used to be 2.5 kg, now it is 250 kg." Went viral on social media. Let's understand why he made that threat. Lodhi felt police were exaggerating a minor accident and humiliating his son. He accused officers of acting under directives from Delhi leaders like PM Modi, Amit Shah, or Jyotiraditya SC India. His threat was a display of political muscle flexing, meant to intimidate police and defend his son's political ambitions. Let's understand the story behind the issue. Political pressure. Lodhi is a first-time MLA from Pichore, known for controversial remarks and past criminal cases. Party response was BJP issued a show cause notice calling his conduct highly objectionable. Facing pressure, Lodhi later apologized, saying, "The party gave me a lesson." Public reaction. IPS Association condemned his caste-based and derogatory remarks, while Congress accused BJP of shielding lawlessness. Let's understand the different perspectives on this issue. Supporters' view is that Lodhi was defending his son against harsh police action. Critics' view is that his remarks show abuse of political power and undermine the rule of law. Balanced view is that the case highlights tension between political influence and police independence in India's government system. The controversy is not just about Kauda. It is about the clash between political power and the rule of law. Whether leaders respect institutions or intimidate them will decide the strength of India's democracy. Today we will uncover the Adarsh Credit Cooperative Society scam in Rajasthan. A rupees 50,000 crore fraud that robbed ordinary people of their savings. The Adarsh Credit Cooperative Society scam in Rajasthan is a massive 50,000 crore fraud where lakhs of small investors were cheated. Former Chief Minister Ashok Gehlot has accused the current BJP government of mishandling the case, saying victims are still waiting for justice despite Enforcement Directorate asset attachments. The controversy now also involves allegations of conflict of interest in legal representation. What is the Adarsh scam? It is an institution, Adarsh Credit Cooperative Society, which was founded in Rajasthan, claimed to be a cooperative offering high returns. Modus operandi is it collected deposits from lakhs of investors across Rajasthan and other states, promising interest rates much higher than banks. And the reality is money was allegedly diverted into shell companies and personal assets of promoters. And the scale of this issue is it estimated fraud of 15,000 crore, making it one of the biggest cooperative scams in India. Why it became a scam? Ponzi-like structure. New deposits were used to pay old investors. False promises. Investors were misled with fake assurances of safety and high returns. Weak oversight. Cooperative societies are regulated differently from banks, creating loopholes. Who are involved in this scam? The promoters such as Mukesh Modi and family who ran the cooperative. Accused is several directors and associates facing charges under the IPC and Prevention of Money Laundering Act. Government allegations. Ashok Gehlot claims BJP government allowed the racket to flourish and is now mishandling recovery. The victims are lakhs of small investors such as farmers, pensioners, and middle class families who put life savings into others. The impact is many lost their life only source of financial security. Let's see the case details. ED action. Assets attached in 2019, 2021, and 2024. And the court cases are multiple FIRs and PMLA cases were filed. And the conflict of interest allegation. Gehlot pointed out that the same law firm was representing both the state government and a co-accused, raising questions of fairness. Collective action. Victims have filed petitions demanding repayment, but no clear mechanism has been implemented yet. Let's understand the constitutional and legal basis governing this issue. Article 21 protects the right to life and livelihood. Victims argue their savings are part of this right. Cooperative laws, which are covered by the State Cooperative Acts and the Multi-State Cooperative Societies Act. Prevention of Money Laundering Act 2002 allows the Enforcement Directorate to attach property acquired through fraud. IPC bargain and Sanjay provisions. Charges of cheating, criminal conspiracy, and breach of trust. Judicial oversight. Supreme Court and High Courts can direct governments to ensure independent and fair investigation. So the other scam is not just about numbers, it is about trust broken for lakhs of families. The Constitution gives protection to people's rights, but unless governments act transparently, justice for victims will remain a distant dream. Leaving you on that note, thank you for watching.